Hello, everyone. Welcome to this debate, co-sponsored by the Marin County chapter of the League of Women Voters and the American Civil Liberties Union of Northern California. My name is Lori Nardone, and I'm with the League of Women Voters. Thank you also to a number of other volunteers from both organizations who are helping tonight, including our timekeeper, Elaine Biagini. The candidates running for District Attorney of Marin County are Lori Frugoli, Marin County Deputy District Attorney, and Anna Pletcher, former federal prosecutor. I'm going to say something in a bit about not clapping. I will get to the not clapping part just so we can make full use of our time. So before we get started, I get all the housekeeping announcements. So we'll start with the Community Media Center of Marin. They're going to video record, live stream, and later broadcast this forum on local cable and satellite TV. Release notices have been posted around the chamber to advise you that your presence as a member of the audience during this event constitutes your permission for us to record and broadcast your image and voice. No other recordings will be allowed because the FCC requires that candidate debates or forums must be broadcast in their entirety and unedited, either live or reasonably soon after taking place. This means no recording, even on your cell phone. And speaking of cell phones, please take a moment to silence yours now. Don't be that person whose phone rings at an inopportune time. Because we are strictly nonpartisan organizations and we are following the FEC rules, no campaign material, including buttons, signs, brochures, t-shirts, etc., is permitted in the hall. However, brochures may, with permission, be placed on a table in the entryway after the forum has concluded. We expect candidates and audience members to remain civil and courteous throughout this forum tonight. We are requesting that the audience not make or yell comments or applaud individual candidates' answers or questions. Please let us use this evening for how it was intended, as an opportunity to listen to and to learn from both of our candidates. Before we move forward, we have a short video that we want to show you to ground us on one of the many powers of the district attorney. So if you could turn your attention to one of the monitors.
My name is Frankie Guzman. I am a staff attorney at the National Center for Youth Law. I'm also the director of the California Juvenile Justice Initiative. When I was 15, I was arrested for armed robbery, and it amounted to me basically doing a favor for my friend. Unfortunately for my friend, he was 16 years old and had one prior arrest for possession of a stolen check. Meanwhile, at the time of my crime, it was my first offense and I was 15. The prosecutor successfully argued for my friend to be tried in adult court. My friend lost his fitness hearing and was convicted in adult court for robbery and was given a 7-year prison sentence. Fortunately for me, because of it was my first offense and my age, I was kept in juvenile court. And so it was not for lack of trying. The prosecutor tried to get me in adult court and lost that hearing. And after that, he really gunned after me going to the state system, to the Division of Juvenile Justice. Back then it was the Youth Authority, and succeeded on that ground. And so, when I think about what the prosecutor could have done, in the first place, he could have acknowledged all the disadvantage that I had come from and the reasons for why I had maybe, engaged in negative behavior or exhibited some problematic behavior, and should have sought to deal with that. But instead, what he did was, he saw a disposable child that he tried to characterize as a menace and did his best to get me to go to prison. Unfortunately for him, or fortunately, he was not successful. But through it all, I did get an extreme result. I went to the California Youth Authority, which is our youth prison system, at a time when we had 11,000 kids in a system designed to hold 6,000, and I experienced more trauma than I ever had experienced in my life growing up in a disadvantaged community. And so for me, a progressive prosecutor would be somebody that would focus on healing, on restoring, and not simply punishing, because punishment, I think, has very little to do with justice. Retribution is just one aspect that the justice system should be focusing on. It should be on restoration and making people whole. So when you think about the case of a victim of violent crime, to not look at the perpetrator as a victim of his own set of circumstances is to be very short-sighted and closed-minded to the reality of the situation. I think you will hear it many times in conversations about crime: hurt people. And if the prosecutor is not focused on healing both parties, the defense, the defendant and the so-called victim, then he's not doing, or she's not doing, her job. And so for me, a prosecutor that does not focus on healing, that does not focus on restoration of all sides, is an irresponsible and unaccountable person. To put it bluntly, I believe that prosecuting kids in the adult system is immoral, unethical, and unjust, and it needs to stop. If for no other reason, because it's disproportionately impacting Black and Latino youth, young people who are, because of our history in this country, perceived as less deserving and more dangerous. And because of that, we oftentimes bear the brunt of our harsh criminal justice practices. But through it all, as an attorney, I see young kids with privilege, kids with means, be diverted out, be given these opportunities to make good with their life in spite of having committed serious crimes, and do well with themselves. And so for me, there's no question that all kids can benefit from rehabilitation. The fact is that some kids, Black and Latino kids who look like me, don't get those opportunities. And because of that, I decided to make my life and my career meaningful in a way that would help people like me coming after me have chances that I never got.
Okay, so we wanted to show you that just because this position, we wanted you to get a view of what does this position actually entail, and Yoel will talk more about that. Just a few more things before I turn it over to him. Because this is a debate, we will not be taking audience questions tonight. We have a number of debate questions that have been jointly composed by the League of Women Voters and the ACLU. Each candidate will have up to 3 minutes to respond to each question. We'll rotate the response order, and after each candidate has had a chance to respond, we will allow up to 1 minute for rebuttal or elaboration. And then our debate moderator will have the discretion to possibly ask a follow-up question with 1 minute allowed for each of them to reply. So before I turn it over to Yoel, we would like to ask each candidate, they have been invited to make a 2-minute opening statement. And we will start with Lori Fergoli for your opening statement. Welcome, both of you.
Can everybody hear me? Thank you. Good evening. I'm Lori Fergoli. Thank you to Mayor Phillips, the League, and also ACLU for hosting us tonight. I sit here tonight a proud representative of the District Attorney's Office. I have proudly been a prosecutor for 28 years, and I'm not ashamed to say I'm a prosecutor. I'm also not ashamed to say that my office does have restorative justice programs. Some of you might be thinking that we don't. We're kind of left in the dark ages, but we're not. We actually have several restorative justice programs, including a drug court, a STAR court for mental illness people, and one of my colleagues, AJ Brady, actually started a program called CAGI, where we provide housing and treatment for our chronic inebriants who you sometimes used to see downtown. So we do have a lot of restorative justice programs in our office. Now, a little bit about me. I grew up here in Marin, attended local schools, went to Mary Silvera, Miller Creek School, Terra Linda, and so in 28 years, I've had 100 jury trials of all makes and models. It's important to me, and it's a sad fact that all those nice things I told you that we do in our office, the community doesn't know about them. And that's why my platform is connecting the community to the courthouse, so that you learn and understand and see our faces and hear our voices and know exactly what we're doing to serve you, because that's our job, is to serve you. I am supported by people who have held this job before, the current district attorney and the last 3 district attorneys, and I'm supported by the staff in my office, which I'm very proud of. My platform is set forth on a document outside there. Day one, I knew what my platform was. It's protecting this community, everyone in our community, seniors, veterans, people addicted to opioids, and it's all set forth here. And I look forward to your questions tonight, and I thank you for being here. Thank you.
Thank you, Lori. Anna?
Thank you. Thank you to Mayor Phillips, the ACLU, to the League of Women Voters, and to all of you for being here tonight. I am a career federal prosecutor, law professor at UC Berkeley and UC Hastings, and the mother of 3 children here in Marin. When I was a special United States Assistant Attorney working in the Major Crimes Unit, I prosecuted a wide variety of cases. Criminals from bank robbers to internet predators to corporate fraudsters. I took on corrupt real estate agents and got $6 million for victims of home foreclosures, fraud, and bid rigging. I'm the only candidate who is a manager who actually ran an office when I was assistant chief and running an office of 25 people. I am running to bring justice with integrity to the Marin DA's office. As district attorney, I will make sure that we have rape kit examinations here in the county for victims of sexual assault, instead of sending them hours on a drive to get the care that they deserve. I will protect the environment and prosecute toxic polluters. The Marin County DA's office hasn't brought an environmental case in decades, and I will change that. I will protect our immigrant community. I will stand up to ICE and make sure that we create a safe place for all of our immigrants and everyone here in Marin County. And lastly, I will tackle homelessness by partnering with mental health providers so that we can stop the cycle of people rotating through our criminal justice system. And despite the misleading claims of my opponent on the flyer that she just showed, I'm proud to be endorsed by the Marin Democratic Party, the only candidate, to be endorsed by the Sierra Club, Supervisor Kate Sears and Dennis Rodoni, 6 mayors in Marin County, and many more. I am proud to bring justice with integrity to this DA's office. Thank you.
Thank you. Okay, now I am delighted to turn the mic over to our moderator, Yoel Haile. He's a criminal justice associate with the ACLU of Northern California, whose focus is around prosecutor accountability in the 11 largest counties in California. Thank you, Yoel, for coming here. We very much appreciate your lending your expertise to moderate our panel. It's all yours.
Thank you. Good evening, everyone. So today we have 5 topics that we're going to ask the candidates about. The topics are mass incarceration, juvenile justice, immigrant justice, police accountability, and gender justice. You've heard the rules, candidates, of, you have 3 minutes to respond, 1 minute for rebuttal, and 1 minute to respond to a follow-up question should I ask one. So the first question on the topic of mass incarceration is, due to the signing of SB 10, the bail reform bill that was recently signed, and the appellate court's decision regarding Humphrey, which mandates consideration of ability to pay before imposing bail, it seems that California counties will soon have to make major changes in their procedures and principles for deciding whether and how arrested people are released before trial. What recommendations would your office make, should you be elected district attorney, about this? Meaning the question is, how will you continue to push drastically to reduce the number of people who are held pre-trial in Marin County? These are people who are legally innocent, they have not been convicted of a crime, but who may be sitting in county jails.
Who do you want to start with?
We can start with Ms. Anna.
Thank you. It was Bobby Kennedy, more than 50 years ago, who changed the federal bail system to eliminate cash bail. California is a long ways behind on this. So our movement now, what we finally were able to do in the legislature in passing SB 10, is to catch California up to where much of the rest of the country has already been for a very long time. So there's nothing new, there's nothing novel about eliminating cash bail. In fact, we know that it is the just thing to do. And as a federal prosecutor, that's the world that I lived in, one without cash bail. Instead of putting people in jail depending on how much money they have in their pocket, the alternative is a risk assessment. And this is the system under which I spent my whole career as a federal prosecutor. And what that means is that a judge will get a lot of information about someone who comes before them, and they'll be able to decide what's the least restrictive means, meaning what's the smallest thing we can do to make sure that people come back to court and that they're not going to commit another offense. And there are so many options. It can be as simple as a text message. There's a great study in New York that showed that failure to appear, people not showing up in court, drops from 40% to 20% just by giving text messages. So as district attorney, I'll start there with the simple things we can do to make sure that people know about their appointments in court, that they have those text messages and those reminders. We have other options too. We have ankle monitors, and we have regular reporting to our pretrial services system that we will have to build. Again, this is something that we can do, we can lead in Marin County. And with my experience as a manager in building relationships in the county, I have the relationships with the probation office, with the Board of Supervisors, to make sure that we do this in a way that is safe for everyone and that actually moves us forward. I'm looking forward to implementing it in Marin County. And we should take care to remember that implementation is the key. We must eliminate the racial bias that has infiltrated our system, the socioeconomic bias, and we do that by making sure that our risk assessments are fair, are balanced, and that the district attorney is right there making sure that it happens the way it needs to, delivering justice with integrity. Thank you.
Thank you. Ms. Frugoli?
Thank you. I want to go back a little bit and talk about how we handle cases right now with bail. Until October of 2019, we do have cash bail in Marin County. I actually wrote an op-ed for the Marin Independent Journal explaining all the things that we do in Marin County to give options to people who are in custody pre-trial so they don't have to remain in custody. We do have ankle bracelets. We have bracelets to detect if a person has ingested alcohol. We send people to programs, and our public defender's office has a wonderful gentleman who keeps tabs of people and gets them to appointments, gets them to treatment programs. So we're doing a lot of wonderful things already. I'm sure those things will be incorporated into the new bail system. But my point is, when we started this campaign, Ms. Pletcher was pushing a different form of what is now our law, and she was adamant about it, and in the newspaper actually challenged myself and the other gentlemen in the race to join her in pushing forward that version of the bill. Well, that bill didn't pass. That bill was actually pulled by the governor and the Chief Justice of the Supreme Court because it wasn't ready. People were pushing it, trying to get it through, when they had yet to receive some very important information, data, and documentation from judges throughout the state that had been appointed by the Chief Justice to study bail systems throughout the state and provide a report with important information so that they could make an informed decision on what's the right way to go with this new bail and not. So that legislation that Ms. Pletcher endorsed and pushed was pulled, and it came back and was recently passed. And so in October 2019, we are going to have no cash bail. There are some bail bondsmen who are attacking that by lawsuit and trying to put it on the ballot. I don't know whether or not that's going to be successful. But regardless, there is going to be a system in place for a judge to make a determining factor, depending on if it's a misdemeanor, which is a low-level offense, or a felony, as to the risk of the offender to the community and what kind of safety danger do they pose, low, medium, or risk. How is a judge going to make that decision? That's the big question. because there's nothing set forth in how each county is going to make that determination. That's where my office needs to be involved. Probation has already met with the Human Rights Commission and advised them what they intend to do as far as that goes. They're going to be a key player in this, and our probation already is a key player in bail and own recognizance situations as it is. So I think at the end of the day, it's a very complicated new law. I think there are, frankly, some defense attorneys who aren't in favor of it because I've been told that some of their clients would end up staying in custody when they could have made bail before. But it's what we have, and we certainly need to be a piece of it. So thank you.
If I may, Ms. Frigoli misstates
1 minute rebuttal.
my position. I am proud to have led the fight for bail reform in Marin County. Because when you base somebody's freedom on the amount of money that they have in their pocket, that is wrong. That's not the justice system that we want. That's not the system that I believe in. So I came out very strongly in favor of fixing our bail system, and I stand with that today. Now it's about the details. How do we get it done? I've actually done it. I've operated in a system without cash bail, and I know that we can do it here in Marin, and I will be able to implement it here the right way.
Ms. Frigoli, if you want to rebut that, you can have 1 minute.
Sure, I don't need a minute. I think when you proposed to push something through that the governor and the chief justice had found was flawed and was replaced with something that focuses on safety, then I think that shows why an experienced person should be in this position. Thank you.
Thank you both for your responses. Our next question is regarding probation. Studies have shown that the optimal length of probation is 18 months. Alameda County has already moved away from giving automatic 5-year probation terms to 3-year probation terms. Should you be elected to the district attorney's office, would you instruct your deputies to only seek a maximum of 3-year probation terms for most cases? Ms. Frigoli, you have 3 minutes.
Sure. Are you talking all crimes, felonies, misdemeanors, or just as a general policy?
As a general policy.
Well, as a general policy, when it comes to supervision, there's misdemeanants who are not supervised by a probation officer. They're basically supervised by the court. In many of our cases, we only ask for 1 year supervision. In a DUI case, driving under the influence, we ask for 3 years standard. It's very rare in any case, even a serious felony, frankly, that we ask for more than 3 years probation. If a person has multiple DUIs, we will ask for that. If it's a sex offense, we will ask for that. If there's significant issues before that, or if there's a record and a reason for that, a judge and my office in probation always takes into account mitigating factors and aggravating factors in every case and every client. So that's an issue. But oftentimes when we ask for 5 years probation, which is very rare, I'd say in my case it happens maybe once or twice a year. If a person does well on probation, I always make it part of my plea agreement that if they do well, they can get off probation early. And I often do that sometimes even when I recommend 3 years. So I think it's a case-by-case situation, but in general, I don't see a problem with a 3-year probation. And sometimes people really do well sooner than that. And we applaud that and reward people for that by terminating their probation.
Thank you. Ms. Pletcher?
Yes, we should be reducing the lengths of stay on probation because, in general, yes, a 3-year maximum, absolutely. But let's ask what the purpose of probation is, right? It's to make sure that people stay on the right track. And that's what I'm doing is just what I'm trying to do as district attorney is get to the root causes of crime and make sure that people stay on the right track, that they're not reoffending. And that means that what we really need to be doing is investing in programs that will give people the skills and the opportunities that they need to stay on the right track. That means investing in diversion programs. That means investing in job training, in opportunities that will keep people going in the right track. And one of the challenges that we have in understanding the lengths of probation terms and what we need to be doing going forward is the lack of data. that we have on our Marin County District Attorney's Office. In many ways, it's a black box. We do not know exactly how many people are coming through on probationary sentences, how many are being released early, and giving that information out to the public and into the DA's office so we can analyze it. As a manager, an experienced manager, I know that we need to be looking at the data to understand, is this working? Is this working? And when I'm asking myself, what is the right length of probation? I need to have the data. And as district attorney, I'm committed to gathering the data that we need and analyzing it so that we will know what our best practices will be. And we can adjust to make the right decisions based on the data.
Thank you. Our next question is with regards to plea bargaining. In plea bargaining negotiations, the common practice in many counties throughout the state is for prosecutors to overcharge and threaten to seek the harshest sentences if people insist on their constitutional right to a jury trial instead of accepting a plea deal. Should you be elected a district attorney, will you commit to implement a policy that the sentence offered at the plea deal stage would not be increased if a person chose to exercise their constitutional right to a jury duty? Ms. Pletcher.
I do not believe in overcharging. I think that's a dereliction of the duty of the prosecutor. Now, plea agreements are a necessary part of our system. When somebody is admitting that they did something wrong, that's a good thing. We can come to an agreement that saves resources, prevents lengthy trials, but the agreement has to be one where both sides have a fair shot to get the best representation and to come to an agreement that makes sense for everyone. So we have to be thinking about due process, victims' rights, and balancing all of those things. So plea agreements are important. They're an important part of the system. But bargaining charges away is never something that I've done as a prosecutor, and I won't do that here in Marin County either. That's why I've been talking about justice with integrity. That's what that means. It means making sure that every plea agreement that we make, where we follow due process, there's full discovery, full disclosure, then we can get to an agreement that is fair for both sides.
So just so I have clarity, and let me clarify the question. So in examples, right, somebody does something, is arrested, the plea offer they get from the district attorney's office says, if you admit and sign this plea deal, you will get 5 years. The person says, no, I would rather take my chances at trial. Then the DA's office makes the decision that if this person is convicted, that the DA's office will seek, like, let's say, a 10-year sentence from the judge. So the question really is trying to get at the heart of, if a particular crime today was worth 5 years in the eyes of the DA, why would it be worth 10 years because the person chose to exercise their right to go to a jury trial? So the question we're asking is, if in cases like these, would you instruct your deputies that they should not increase the time they're seeking simply because the person chose to exercise their right to a jury trial?
I see. Thank you for that clarification. Exercising the right to the jury trial is everyone's constitutional right, and they should feel free and fair to exercise it at their will. As district attorney, it's incumbent upon me to make sure that our DAs are offering fair, reasonable sentences, and those sentences reflect the seriousness of the crime, reflect the victim's rights, and it is very common practice to offer a higher sentence if someone chooses to go to the trial, but that's often not fair. So that's a policy that I will review as district attorney, and I'd like to see what this district attorney's practice is right now, because again, it's something that I do not know, because we do have this black box in the DA's office. So I would take a close look at that.
Thank you, Ms. Pletcher. Ms. Fergoli?
Thank you. What our current policy is, and there's discretion given to our prosecutors, I should say. I agree that it wouldn't be proper to up the ante of a person's sentence recommendation by the people for exercising their right to a jury trial. But we do have in place now, which will be under review. And in fact, I'm going to be talking to the defense bar about how we can make this a better process for everyone. But right now, let's say a person's charged with a felony case. If they take it to a preliminary hearing, which is a hearing to see if there's sufficient evidence for a person to go to jury trial, oftentimes we have a policy that if you go past the preliminary hearing, the offer that we gave beforehand is withdrawn. Now, just because a person takes it to trial doesn't mean that that offer won't be reinstated. During the time window between trial and when the person's been held to answer, there's usually a lot of discovery, a lot of evidence that comes out. Sometimes we find exonerating information, sometimes we find information that's more incriminating, and the bottom line is it's a case-by-case situation, but I'm not saying there haven't been cases where we've withdrawn a prior offer. Sometimes it's a matter of we haven't charged it the way that we could have, and there's additional charges that we offered to dismiss. So I'm not saying we don't withdraw offers at the end of a preliminary hearing, because I know that that does happen. And the other thing that people should understand about how it works in the system is that if a defendant can always go to a judge and get a commitment if they don't like what the people are offering. So there's that option. And the ultimate decider, if you will, of what the punishment's going to be is the judge. And the judge doesn't do that until after a trial and after a report is prepared by the probation department. And sometimes that's when a lot of prior incidents, either good or bad for the defendant, come to light. And the probation department uses rules of court to determine whether or not what they think the proper sentence should be. We have an option to give our opinion, and then the ultimate decider is the judge who heard the evidence at trial. So that's kind of how it plays out, but bottom line, I do agree, it's not a good principle to be punishing someone for taking a case to jury trial. That's not how our system works, and it certainly is not just.
Thank you. Next question is around criminal records and the impact that they have on people, individuals, and communities. Having a criminal record puts major barriers in the way of people obtaining or keeping employment, housing, education, and many other opportunities. Will you commit to automatic expungement of records for old convictions that are now legal under Proposition 64, meaning marijuana convictions, as the San Francisco District Attorney has committed to doing? And the same goes for crimes that were reduced to misdemeanors by the passage of Proposition 47. So the question is, will you commit to the automatic expungement of records that people are entitled to because of the passage of Proposition 47 and Proposition 64, as some district attorneys around the state have committed to doing? Ms. Frugoli?
Yes, thank you. It's actually part of my platform and my policy that I intend to have a special assignment, and that person is going to be designated the social justice district attorney, and their job will be to handle expungements, to go out in the community and proactively solicit cases. But one of the main tenets of that is to expunge, which is take something off a person's record, expunge marijuana convictions, and I'm going to take it a step further and expunge people who have immigration consequences, which is another big issue that I'm sure you're aware of. So there's people who 20, 30 years ago might have pled to an offense that at the time they weren't properly advised of the immigration consequences. It's a different world we live in today as far as the consequences of suffering certain types of convictions. And part of that job of that designated social justice DA will be to handle those cases as well. Are we going to agree to everyone? No, but we're going to handle them in a fair manner and in a merciful way is the best way I can describe it. So yes, I would have no problem with that. And Prop 47, for those of you that don't know, it was a legislation that was passed that made many drug offenses, such as possession of cocaine or methamphetamine, that were felonies. It made them misdemeanors. And so people have gone back. I think last year we did over 200 expungements. And that's the kind of thing that we do that people need to know that we do, so.
Yeah. And just so I'm clear,
Sure.
We're asking for automatic expungements. Typically, the way the expungement process works is that the person would seek and, would file a petition to your office, and then your office would either oppose it or support it, then it goes to the judge, right? And
Right.
the question is, instead of the person having to go through all that hassle, would your office pull those records, expunge them, and notify people that they no longer have those records?
If we could get the manpower for that, we could. And I actually think a lot of that work could be done not necessarily by a prosecutor, but by a paralegal. And so I would have no problem with that. The only proviso I'd have, as long as it didn't involve violence or a firearm. But I think that's not what you're talking about, so.
Thank you.
Thank you.
Ms. Pletcher.
The answer is yes. I believe strongly in automatic expungement because I see the enforcement of our drug laws as being a racial justice issue. And this is a place where we really struggle in Marin County. Marin is the #1 most racially unequal county in the entire state of California, driven by our criminal justice system. And this is an area where it shows, where uneven enforcement of our drug laws falls the most heavily on our communities of color. So proactively expunging these cases is something that we must do as district attorney to address the racial injustices in our county. Ms. Fragoli mentioned that she would appoint a social justice district attorney. In my district attorney's office, every single deputy DA will be a social justice district attorney. That means thinking about the broader implications of every single charge that we bring, the collateral consequences, the deportation consequences. In my district attorney's office, we will be taking all of that into consideration when we charge a case. That's how I believe it should work.
Thank you both. 1
So
minute for
we
rebuttal.
went a little off course. I would like to respond. By law, our office is required to take into account immigration consequences. And I, on many occasions, in fact, this week, was told by a defense attorney, thank you for listening to me. I appreciate that you have empathy. I don't always get what I want, but I appreciate that you listen. And we do follow the law, and we do try and structure pleas when it's appropriate. And more often than not, it is. We try and structure pleas and dispositions so people don't face immigration consequences, because that's our job. And by law, we're required to do that.
Thank you. Ms. Pletcher, you can have 1 minute for rebuttal if you'd like.
Thank you. Our immigrants in our community right now are harboring a lot of fear because of the policies of our sheriff, who is releasing immigration dates, releasing release dates from the jail when someone is released. And Ms. Fragoli is supporting the sheriff's policy, the sheriff. And I urge her to reject his endorsement, because if she truly believes in making sure that deportation consequences are not going to be falling heavily and unfairly on our immigrants, then we actually have to make sure that the sheriff is in line with that as well.
Thank you both. We do have an immigration question down the line, just as a reminder. Our next question is around transparency. Transparency and accountability should be the cornerstones of any efforts to ensure safety and justice for all of our communities. Will you commit, if you're elected district attorney, to quarterly publish data, both tabulated and raw, that includes the demographics of those prosecuted, plea offers that were made, bail recommendations that were made, sentencing recommendations, and cases that are successfully diverted into other non-incarceration alternatives? Ms. Pletcher.
Yes, a resounding yes. Data is so important to making sure that our district attorney's office performs at the level it must perform at. And in my time as a manager, I actually managed an office of 40 employees, 25 attorneys. That means I was responsible for setting the policy, for the budgeting, for looking at that data and asking, are we performing at our best? This district attorney's office has had tremendous failure in terms of data. They didn't publish any performance plan, no strategic plan between 2009 and 2013. I've gone back and I've looked, asking how are we doing and how can we do better? We don't know if we don't have the data. And even the last 4 years that the district attorney's office has published a performance plan, they haven't included any data. So there's no way to hold yourself accountable. You can make all of these great promises about what you want to do and about about bringing these great changes to the DA's office, but if you don't have the management experience and you don't have the commitment to getting the data, then you'll never be able to hold yourself accountable. And that is something that I commit to doing.
Thank you, Ms. Fragoli.
Thank you. So my platform, which I said day one, was on the internet. Reform the culture of the office to make it more inclusive, transparent, and accountable. So I have always committed to that. Does our office need change? Absolutely. Is it going to happen? Absolutely. The real question is, who is the most qualified and experienced and capable to lead this office to the future? That's why I knew we needed to make changes, and I was willing to acknowledge it from the outset, the kind of changes I'm going to make with clarity and specificity. So I encourage you to look at my platform. I have always said that I was going to establish a dashboard so that when the community goes to our website, not a Facebook page that shows what we're doing in the community, which is a different issue, but they can go to our dashboard and actually see what we are doing. How many cases did we receive? I agree, our data presentation to the community has not been, we don't have a good record of that. And I'm here to change it. That's why I put that in my platform. And I think part of change and showing responsibility is acknowledging when there's a problem. If you don't know there's a problem, you're not going to be equipped to fix it. So I do plan to have a dashboard, and it will have all the data that you were asking about. The number of cases that we took in, what communities they came from, the races and demographics of the people who were involved, and our jury trials. We don't publish our jury trials either. So there's a lot of data that the public, as I said, we work for you. You're entitled to know this, and you deserve to know that. You also need to know all the good things we're doing, how much time we're spending in our drug court, in our mental health court. There's hours and hours of time that we spend collaborating with other community leaders and public defenders and probation officers, helping people so that they don't come back and don't violate probation. We never quantify that, and we're going to start quantifying that. So I do agree that we should be certainly more transparent. I also plan to have an open door policy, not only to the community, but to defense attorneys. I was speaking to a defense attorney this week about a strike. I don't know if people know what a strike is. It's when you suffer a serious or violent felony, and if you pick up another one in the future, it can really have significant ramifications. So we have a committee that reviews whether or not we should be basically not considering those as far as sentencing. When we take the case before the judge, we can actually move to strike it, as can a judge. Well, our committee never personally hears from the defense attorneys. We ask them for information, we solicit it. But part of my policy and my open door policy is going to be when we have strike cases and a strike review meeting, we are going to invite the defense attorneys to come to us to make their presentation for their client. Thank you.
Thank you. If 1
Yes,
minute for
yes,
rebuttal.
thank you. Managing an office is a different skill set than trying cases. I've done both. And I know that you're not born with either. You have to develop the skill set. The district attorney is an executive and county department head. That means the DA needs to be trained and understand how not just to post data on a website. Anyone can post data on a dashboard. The DA has to know how to analyze that data. To analyze it to make sure that we're getting the best performance out of the district attorney's office, the best projects, the best policies, the best procedures can only be done with thoughtful analysis from someone who's trained to do it. I'm the only candidate with that skill set, and Marin County deserves that kind of thoughtful management.
Thank you, Ms. Fragoli. You may have up to 1 minute
Yes,
for rebuttal.
thank you. So now we've gone down another rabbit hole, but I just want to reiterate, this is not just a management position. If that were the case, we could just hire somebody to evaluate data. There's lots of people that we would pay less than we'd pay an attorney to evaluate data. I think the San Rafael Police Department and the city of San Rafael does that on a regular basis. This is about managing a team in an office that's protecting you of trial attorneys and their staff. And my staff has actually asked me to ask Ms. Pletcher what her trial record is, because that's what we do. We conduct trials. I would like to hear Ms. Pletcher's information and documentation about how many jury trials she's conducted in state court, if any. Has she conducted any jury trials by herself? Because my staff and colleagues are concerned that perhaps she might be the least experienced trial attorney in our office. And I think that's a question that it's time to be answered. Thank you.
Thank you both. Our next question is on racial disparities. Racial disparities plague every stage of the criminal justice system, from over-policing to over-criminalization and over-incarceration of Black and Latino communities. If you are elected district attorneys, what will you specifically do to reduce racial disparities within your first term? Ms. Fergoli.
So I think we are back to the data. You can't really address an issue fully unless you have the information on where that's occurring. We know it's occurring because the Race Matters data report tells us that. It didn't tell us where specifically it was occurring. So I think that's one thing that when we have the dashboards with that data, we see where our cases are coming from. I think that'll help give us some insight as to where it's coming from. And then you have to own it. You have to own that there is racial disparity happening. And sometimes people need to be confronted with that evidence. So I know there is a huge disparity in our youth court, and the leader of our youth court is here, and it's very difficult to get a child of color into our youth court despite the fact that it's available at our civic center. And that's something that really needs to change. And I think starting the change of disparity with our children is a start. And documenting it, and if officers are acting improperly, then we need to take care of it and address it. I have prosecuted police officers before. Nobody's above the law. And I think that's another issue that needs to be addressed. So other than that, the fear factor with the immigrant community is an issue. I know they're not reporting a lot of crimes, and we need to be out in the community and really letting them talk to us, tell us their concerns, and we need to be listening to them to see what we can do to make them feel safer. One thing I am in support of that does stop some of these problems are diversion programs and restorative justice programs outside of coming into the criminal justice system. And that's what our youth court is. So that's just off the top of my head, my first reaction of how we should be addressing this. But it's a countywide problem. But until we get the data to see where it's occurring and take measured steps to address it, it's an issue, and it's been documented. So now we just need to get on it. But I think we need to start with our children. We need to have our officers owning this too, and their leaders, their police chiefs, and also be out in the community with, there's a wonderful program called Not in Our Town, which is an anti-bullying program. I fully support that program. I'm involved in it in Novato. I think we need to be fostering that program so that the community is also aware of when these things are going on, whether it's bullying by somebody in the community, or I think your example is more bullying, in essence, by law enforcement. Thank you.
Thank you. Ms. Pletcher?
Thank you, Ang. This is why we need change at the district attorney's office. It's been more than 80 years since someone from outside the office has had that job. It's just been handed down from one insider to the next, to the next, to the next. And Marin County is #1 in racial disparities for a reason. It's led by our criminal justice system. That means that our DA's office has been part of the problem for a long time. And how do we fix that? It starts with leadership. It starts with a district attorney who has the courage to come right out and say, yes, we have a problem here, and I'm going to commit myself to fixing it. That means that we make sure that everyone has equal access to restorative justice programs. That means that we look inside our own district attorneys and look at our own internal processes, our own systems, to say, where's the institutional bias? Where are the systemic problems? Do we have a diverse enough workforce? When I was assistant chief in my office in San Francisco, I created a program I created an internship program that creates a diverse pipeline of attorneys coming into the office. I will do that here at the Marin DA's office. It starts with looking inside our office and asking ourselves, how do we make it better? And it starts with going out into the communities and making sure that we are part of those communities. in this expungement question that you asked, for example, I would actually go out into our communities where we're seeing the greatest racial injustices. Set up a table in Marin City, in our community right there, and get those expungements done. We're in a way where we can build that strength and that trust within the community. The same goes for our immigration. I know that we're going to speak about that again soon, and I'm looking forward to that. And we cannot be afraid of the data. We cannot be afraid. Our district attorney's office for many years has not done this. It takes outside leadership, thoughtful management, and courage to go out there and get that data to change the way we've always been doing things, to get to the place of justice and integrity, and that's where I'm going to take the DA's office.
Thank you both. 1 minute for rebuttal.
Thank you.
For Gordon.
Again, my whole point of connecting the community to the courthouse is doing exactly what Ms. Pletcher is talking about. I don't think we really disagree on the fact that we need to be out in the community fostering trust. I've spoken at immigrants' rights meetings, at human rights meetings, attended cultural events, and been to leadership meetings down in the canal on Friday nights. And that's an important thing, not just the leader, the district attorney, but everyone in my office and our staff is going to do. And I do agree, you know, the proof is going to be in the data that is going to be under, it sounds like both of our administrations, no matter who it is, it's going to be out there for people to see and own. And there is an issue in our office of racial disparity. We could use more people of color, and it's been very difficult to recruit employees, despite my colleague here in this room, Mr. Bruce, is I think the only African American after 28 years to be in my office. He's still standing, and he's still mentoring students, and we need to keep doing that. Thank you.
Ms. Pletcher, 1 minute for rebuttal.
Actions speak louder than words. For years, I have been working in our local Marin community to address racial disparities and to lift up the communities of color in our county. I've been a volunteer judge on youth court for many years. I started a program to teach the Constitution that I've been teaching to kids at MLK in Marin City for 6 years. 6 years, and I've seen firsthand the challenges that those kids are facing. When I come in there to teach that class, and the kids ask me, the first thing they ask me is, how come I keep getting asked to open up my backpack with police officers? When they're asking me questions like that, and I know that my kids at Tam High are not being asked those questions, I know that we have a problem, and I've been working to fix it for a long, long time, and that demonstrates my deep commitment to this issue.
Thank you both. We will now move from the topic of mass incarceration to the topic of juvenile justice. First question is, will you commit to not charge youth with misdemeanors and to instead divert them pre-plea to community-based alternative programs? Ms. Pletcher, I think it's your turn.
Yes, I will commit to divert youth to community programs. I have been volunteer judge on youth court, as I mentioned, for several years, and I'm proud to have the support of Don Carney, the youth court director, because I have been in the trenches making sure that our kids stay on the right track. I also sit on the wellness board for the Tam High Unified School District, making sure that our kids at Redwood, Tam, and Drake have access to on-site mental health counseling, confidential, free, and that we can expand that to the rest of the county. This is what juvenile justice should look like in Marin County. It means that all of our kids go to restorative justice first, before we even consider juvenile hall and probation. And it works. The recidivism rate for our youth court is just 8%. That's stunning. That's stunning. This isn't just a matter of feeling good. This is a matter of doing the right thing for our kids and doing the right thing for our system. We are actually saving taxpayer money with programs like this. And when we know that kids are on the right track and that they're not going to be committing crimes in the future, absolutely. And I also fully support the legislation that's going through the California legislature right now to prevent children ages 14 and 15 from being charged as adults. I fully support that. Those are teenagers, they are kids, and we should not be sending our kids to adult prisons.
Thank you. Ms. Fergoli?
It's a really broad question, and because I have so much information about different crimes that could be misdemeanors, it's a little difficult to answer. In general, yes, I do agree with that principle. And if you're talking about diversion being a less formal type of supervision where a person could earn a misdemeanor, or, excuse me, earn a dismissal, or their case would be dismissed, I'd be fully in support of that as long as the facts and the situations support that. I mean, there are some violent offenses that could also be misdemeanors, and a person might need more supervision. At the end of that period, I would still agree to a dismissal if they were successful. So in general, yes, but I would hate to give a blanket if some horribly violent misdemeanor came out that it wouldn't be right for us. That's my only kind of proviso with it. But in general, yes, I would agree to that.
Thank you both. The next question on the topic of juvenile justice still is that, will you commit to divert young people under the age of 25, given the science, the development science that has emerged recently that young people do not reach their full faculty and capacity until their mid-20s? Will you commit to divert young people under the age of 25 who are facing felony charges to community-based alternatives like the young adult court being implemented by the San Francisco County District Attorney? Ms. Vergoli?
I think, like a lot of the questions on this, the ACLU questionnaire, the term felony is such a broad term that I couldn't say yes. In general, yes, unless it was a violent or a serious felony where somebody was injured, then it might need more scrutiny. So I just have an issue with the fact that it's so broad. But in general, as long as it wasn't a violent crime or somebody was injured, I would have no problem with that. But a felony is a very broad, I mean, murder's a felony.
Right.
So that's always a little bit of the rub with these questions, so thank you.
In the San Francisco District Attorney's program, murder is not included in that. You may already know that. But
I actually am not aware of their program, so thank you.
no worries. Ms. Pletcher?
We know that young people do not have fully developed executive function, meaning that their brains aren't working the same way as adults, which means that we need to understand that. We need to accommodate that in our criminal justice system. It means that we need to use, for example, trauma-informed practices as a district attorney when we're thinking about how to charge a case. We need to ask, what trauma was this person going through when we think about how we're going to charge this case, and when and how we're going to use diversion. I'm not aware of the San Francisco program either. It sounds like it is a very promising one, and it does need to include, I believe it does need to exclude certain extremely violent crimes so that we can have broader leeway to make sure we come up with the right charge in cases like that. But yes, we know that our kids take a long time to develop, especially kids who are coming up with trauma-informed trauma issues. And that means that our diversion programs need to be more robust. And as district attorney, I will be focusing on creating diversion programs that work, that can take our kids, get them the treatment that they need, because often there's drug and alcohol issues involved. We want to make sure they get the treatment that they need. We want to make sure that their mental health issues are addressed. Right now, 1/3 of the people in our jail here in Marin County are here for mental health issues. As district attorney, I will address the issue of mental health, not just among our kids, but among our adult population as well. And that goes to making sure that we can have diversion programs that can funnel people into treatment instead of into the revolving door of a criminal justice system that we have.
Thank you both. We are now moving to the next topic, a topic both of you have spoken about, which is immigrant justice. Will you instruct your deputy DAs to speak out against the presence of ICE agents in the courtroom? It's a two-part question. And the second question is, will you fully comply with Penal Code 1016.2, which mandates that DA offices fully consider immigration consequences when preparing charges and plea offers? And we know that the law mandates DA offices to consider immigration consequences, but we've also seen in practice a lot of times what will happen all over the state really is, a deputy would say, I've considered the immigration consequences, I still have the same offer. So the question really is, how will you ensure that your deputies are complying with considering immigration consequences? And then the first part of the question is, will you instruct your deputies to speak out against the presence of ICE in your courtrooms? Ms. Pletcher, I think it's you.
Yes. The presence of ICE in our courtrooms is a deterrent to the service of justice. We want to make sure that every person in our community, regardless of their status, feels comfortable using our criminal justice system. We want to make sure that witnesses to cases can come into our courtroom and feel comfortable testifying. That is the obligation of the district attorney and every law enforcement agent here in Marin County. And as district attorney, I will stand up to ICE. I will join our Board of Supervisors in supporting publicly our sanctuary state and protecting our immigrant community here, making sure that everybody feels safe and comfortable relying on our criminal justice system. And frankly, we have a difficult situation in Marin right now because of the sheriff's stand on releasing release dates to ICE. It's created tremendous fear in our immigrant community to the point where people don't feel comfortable going to food banks or going to get health care or dropping their kids off at school. That is not the kind of community that we want. And as district attorney, as an important voice in the law enforcement community, I will be public and vocal about my support for the sanctuary state and my commitment to keeping individuals safe. And that means saying to the sheriff that his policy is actually endangering the safety of people in Marin County. And again, I call again on my opponent to reject the endorsement of the sheriff, who truly is endangering people in Marin County with this policy that goes above and beyond what even the most conservative sheriffs in the state of California are doing. We need to focus on what matters, and that means keeping people safe, making sure everybody feels comfortable with our system, and rebuilding the trust that has been lost in our law enforcement system here in Marin.
Ms. Fergoli?
Thank you. You know, there's a saying, knowledge is power. And I hope all of you in this room and watching this tape go back and look at prior debates where these candidates, myself included, have been asked the question, would you stand up to the sheriff and tell him that his release policy was wrong? And when that question was asked right here in this room a few months ago, I was the only one that answered it. Ms. Pletcher didn't answer that question in the manner she is tonight. Mr. Brady, who was in the race at the time, a colleague from my office, didn't answer the question. I was the only one who answered the question. And I knew it was a tough one, and I know some people think it's wrong that the sheriff publishes the release dates of people from the jail. But what's important to know is that, number one, when the sheriff publishes those dates, it's not against the law for him to do that. So my suggestion was that he should only publish the release dates of people who have felony convictions. I think that would make the community feel a lot safer. Whether or not that'll happen is a different issue. I was at a function today, and Supervisor Rodoni was in the back of the room saying they're having conversations with the sheriff now, seeing if he'll change his policy in different ways. So the board is working and collaborating with the sheriff on those issues. Because the sheriff supports me, I have a much better chance than somebody who stands in his face and says he's wrong of collaborating and having a relationship with him where we can have a give and take. So I think that's an important factor to take into account. Number one, why are we taking this position now when nothing has changed? These release dates have been public for a long time, certainly during the entire term of this campaign. Why all of a sudden now have we taken a different stance and are actually answering the question? Number two, I think it's important as to the release dates that not every person who walks away from the jail acquires a release date. As an experienced prosecutor, I asked the sheriff, what does a person have to do to acquire a release date? If you go to the jail and get booked and say for a DUI and post bail, you don't get a release date. If you get a citation to appear, anybody on the street who receives a citation does not get a release date. If you're in court and you plead guilty to something on a certain day and you're released on that day, you don't get a release date. So there have actually been occasions when I structured plea negotiations taking into account somebody's immigration consequences so that on the day they pled guilty, they got credit for time served. So that's one thing that we can do to help the immigrant community feel safe. The other thing we can do is establish some more diversion programs that would help them not have to come through the system. As long as I've had conversations with the defense, we're working on doing that. So thank you.
So I'm gonna ask follow-up questions to make sure to remind both candidates what my actual questions were. Which is so the question is, this will be to Ms. Frugoli, is that will you instruct your deputy DAs to speak out against the presence of ICE agents in your courtroom? You have 1 minute.
Thank you for the reminder. Yes, I don't think that's appropriate for ICE agents to be in the courtroom, and I think the judge and other people in the courtroom do need to know. I think it's one way that would really discourage somebody from coming to court and actually taking care of their case, which is what we want them to do. So, sorry, I got off track myself, so.
No worries. And I'll ask this again to both of you, and you will each have 1 minute. And my question is, how will you ensure that your office is fully complying with Penal Code 1016.2, which mandates that the district attorney's offices fully consider immigration consequences when preparing charges and plea offers? Ms. Pletcher, you have 1 minute.
It is a management question. The question actually asks, how do you ensure that the deputy DAs are following your direction as district attorney and making sure that deportation considerations are taken into consideration? I've done this. As assistant chief of my office, I set the policy and then had to make sure that the attorneys, the 25 attorneys who were working under me, that they actually followed through. And that requires a system of accountability and transparency and training. Training's critical, and having a good relationship with your employees. I actually had an executive coach for 9 months as a manager. We worked on this. So when I come into the Marin DA's office and I set policy, making sure that the staff, that the assigned attorneys are following that policy is a critical part of what I'm going to be doing. And again, this is a management skill that takes time to develop, that I've developed and will be bringing to the district attorney's office.
Thank you. Ms. Frugoli, same question. Would
Sure.
you like me to repeat it?
I'll answer it. I got it this time. It's something that we can easily track. We have a system when we file cases there's a lot of boxes that we check, including if drugs or alcohol are involved, if a person's injured, been hospitalized, has prior convictions, and that's something that we could and should easily add to our database and track it, because we do have a policy in place. We have training every year on taking into account a person's immigration consequences, but I can't assure you that we keep track of how many times we do that. And I think that's an important question that we need to monitor. So that's something that we'll be doing, as well as tracking the use of guns in that same database. So thanks.
Thank you. Next question is police accountability. Will you publicly support legislation like SB 1421, which is currently sitting on the governor's desk, which will make information public about officers who shoot, kill, or engage in serious misconduct, like falsifying evidence or committing sexual assault while on the job? Ms. Frugoli?
Are you talking about the officer's personnel records or the investigation itself?
I'm talking about SB 1421, which has passed both bodies of legislature and is currently sitting on the governor's desk, which will make public information about officers who shoot, kill, or engage in serious misconduct, like falsifying evidence or committing sexual assault while on the job. This bill, if signed by the governor, would make that information about those officers public.
Got it. Yes. I would follow the lead of the Sonoma County District Attorney's Office when they have an incident of a death of a person or officer and officers accused of using force or violence or police brutality. At the conclusion of her investigation, she will make that documentation and what her investigation revealed as far as witness statements and her legal conclusions. So I think that's something that we need to do, and that's part of my platform of being transparent. People are entitled to know that. And also, by law, we're entitled to disclose that to the defense because it's called Brady exculpatory material. So I hope that answered your question.
Thank you. Ms. Pletcher?
Yes, this is an important part of accountability, of transparency, and I'm very pleased to hear that Ms. Fragoli is supporting the Sonoma County's protocol on this matter, because I've been talking about it through the primary and various debates, and how important it is for the district attorney's office to have a preset protocol that's negotiated and put together by the various stakeholders, including the police officers. We want them at the table when we're negotiating this policy, this protocol. We're looking at what other DA's offices around the state are doing to make sure that we have a protocol that makes sense for Marin County and that's already in place and already public, so that everyone will know when an incident happens. Hopefully it will not. But if something serious incident happens in Marin, we will have a protocol in place. Again, this goes to good management. Basic management practices, getting these protocols done, putting them up on the website so that they're public. The Sonoma County's district attorneys has it up there, and that's critical. That's critical. Transparency, accountability, good management, it all goes hand in hand, and it takes someone who's got the experience, who's done this before, to bring it to this district attorney's office that has lacked it for so many years.
Thank you both. We are very delighted to hear your support for SB 1421. Can we expect, and this is my follow-up question, can we expect letters of support for SB 1421 to the governor from both of you?
I'd have to go back and read it, but unless there's something missing, I would say yes.
Ms. Pletcher?
I agree. I want to take more time looking at it. But I will tell you this, that as district attorney, when there are legislative bills that I support that I believe are important, I will be right there voicing my very public support for them. And as district attorney, I would also have a seat on the California District Attorneys Association, the most powerful lobbying board when it comes to criminal justice issues at the State House. And it's critical for the district attorney in Marin County to make sure that we have a voice in Sacramento on legislation like this, so that before it even gets to the governor's desk, we have had our input here in Marin. And there's this saying that if you're not at the table, you're on the menu. Well, I believe in being at the table in Sacramento when this kind of legislation is being developed, so that we can make sure the interests of the voters of Marin are represented.
Thank you both. Our last question for the evening before your closing statements has to do with gender justice. Given the context of the Me Too movement and the Time's Up movement, along with the serious allegations of sexual assault that have now come up to light with the Supreme Court nomination, what will you do to push the DA's office to more quickly and effectively respond to incidents of domestic or sexual violence? Ms. Pletcher, question is yours.
I have been a long-time advocate of making sure that our victims of sexual assault and domestic violence get the justice that they deserve and the compassionate treatment that they deserve right here in Marin County. From my days chairing the Marin Women's Commission to the seat that I still hold on the Marin County Coalition to End Human Trafficking, this is an area that is close to my heart. It starts with bringing rape kit examinations back to Marin County. We can do this. We can do it for the same cost. We can bring the experienced nurses into Marin. This is going to happen. I'm committed to making it happen. The other thing we need to remember to fight domestic violence, which is the most prevalent violent crime in Marin County, is we must take a collaborative solution. Yes, we must prosecute these cases well, but we must provide our victims with the absolute best comprehensive care. We have the Center for Domestic Peace here in Marin County. They must be involved and involved deeply. Now, some of you may have seen that there was an advertisement that the district attorney's office had posted on bus stops all around Marin County over the last couple of months. A very dramatic domestic violence advertisement saying, call the DA's office. Well, I actually called the number that's on that poster, and it went to a voicemail saying, you've reached the victim witness hotline, leave a detailed message and your call will be returned in the order it was received. That is not the kind of treatment that our victims of domestic violence and sexual assault deserve. What should have happened there is the DA's office should have been collaborating with the Center for Domestic Peace that staffs a bilingual, fully trained, 24-hour-a-day hotline. That's the kind of justice with integrity that I will bring to this district attorney's office to make sure our victims of domestic violence and sexual assault are treated properly, fairly, every single time.
Thank you. Ms. Fergoli?
I do agree. If that happened, I would have thought it would be reported immediately to my office because it's wrong that somebody isn't there to answer that phone. Center for Domestic Peace, I've been in their trainings. They do have 24-hour crisis people who answer the phone, so I think that's an important factor. Calling the police is also an important option for people. Again, I think it's really important for people to understand I'm an employee of the office and I'm proud to be there, but I've never said we were perfect and that change isn't needed. That's why I'm running for this job. Again, the question is, who's most prepared and experienced and understands how this job works? Tonight's the first time I've ever heard Ms. Pletcher talk about bringing an experienced nurse to perform the rape exams, and I'm glad to hear that because initially her statement that the exams had to come back to Marin never included an important piece of the picture, which is she's known since 2014 that these examinations were being conducted when women were victims of sexual assault were being conducted in Vallejo, and she knew exactly why. And it was because the system we had in Marin was inefficient and unfair to victims. You know, when I was a police officer, I was the first person who went to a scene of a young lady, and I can still see her in her living room, and she was bound and gagged with duct tape. And she trusted me as a police officer, and I trusted the people who investigated that case to do right by her. And we moved those exams to Vallejo because we were not doing right by the victims. They were having to wait for hours. And the nurses that were conducting the exams were not certified nurses, they were nurse practitioners. And so they were waiting hours and hours for their exams. So we moved it to a place where there's experts. Last year we had 17 examinations. I have always said, we can bring those exams back to Marin, but not without using the women who have been referred to by the grand jury as the center of excellence. When the grand jury looked at this very question, they called these women and the program who are conducting these exams the center of excellence. It takes 30 exams for a nurse to become an expert. And we had 16 or 17 examinations last year. So I have always said, yes, we'll bring them back, but not without those women from that program. And I think that's an important factor. And it shows why you need somebody with experience who has handled these cases in this position. So I think that answered your question.
Thank you.
Thanks.
1 minute rebuttal, Ms. Pletcher.
I have been working for years to bring rape kit examinations back to Marin County, and the single biggest obstacle has been the Marin County District Attorney. This is because there has been this belief that the only way that victims in Marin can get the best treatment is to send them out to Vallejo, and I know that's not right. And a key piece of my platform has been to bring the nurses on call into Marin County. This has always been my proposed solution, and it's not just me. I've been working with a nurse on the Mill Valley CAN women's rights team to come up with this plan. And we know it can work. We're going to make it happen because the situation right now is just not right. I've talked to victims. We know it's not the best practice. We can do better in Marin, and we will when I'm district attorney.
Mr. Gully, you may have up to 1 minute.
Yes, a colleague of mine gave me this document that was handed to her at Dominican College, I think yesterday or today, and it claims that, it says, vote Anna Pletcher for district attorney. It claims that Mr. Barbarian removed the rape kits from Marin General to Kaiser, and that the county pays for a day of a police officer's time, and that a victim has to wait 4 hours for an exam because the clinicians are based in Napa. I want to know, did this person who claims they waited 4 hours talk to the grand jury? And where did this information come from? What is the basis of it? Again, knowledge is power, and to put this kind of information out without giving the full, complete backstory of the fact that those kits were moved, those exams were moved for the protection of our cases and our victims, and to do otherwise at that moment in time was a disservice to them. Should we move them back? Of course, but only with the nurses. Thank you.
So do you have a rebuttal, Ms. Pletcher?
Well,
So
I
I'll
do.
give one final rebuttal to each, 1 minute. So you may have 1 minute, Ms. Fergoli will have 1 minute. Go ahead.
Thank you. I do not know what flyer this is. My campaign has been very, very thoughtful about putting out all of the information that I've got on rape kit examinations. I've been working on this for a long, long time. I've interviewed victims who've told me what it's like to be sitting, in this terribly traumatic situation. I've talked to defense attorneys, prosecutors, rape crisis leaders, and nurse examiners all around the county for years. That's the kind of diligence that I put into making a policy decision. And when I make a claim that something needs to be done in Marin County, it's because I put in the work, and I put in the effort and the research to come to a decision that I know is right. And I know that this is right. Let's bring those rape kit examinations back, and we can do it the right way.
Ms. Fergoli, 1 minute.
Sure. I've actually taken these cases to court, and the reason why I would not agree to move them unless the nurses from the current program that we are using are involved is because it would be a disservice to the victims. And I think an experienced prosecutor would know that, and we need to protect our victims. They've already been victimized. They can't be re-victimized. At the end of the day, I think we both agree the exam should come back there if we can make it work. We just need to partner with a hospital, and I've spoken to the woman who runs the program of the nurses, and she said she'd need 1.5 to 2 extra people in her pool of nurses to have the availability to come to Marin. So it is doable. Our Board of Supervisors or another entity would have to help fund it, but it is doable. And so the real issue to me is who understood enough from the start to go talk to the people that are running the program and see, is it doable to move these exams to Marin? And absolutely it is, but it has to be done with forethought and knowledge that we need to do right by our victims. Thank you.
Thank you both for answering the substantive questions that we had for the evening. At this point, I'll turn it over to Laurie to help us close it out.
Well, thank you to both of you for being here. This ends the debate portion of the evening. And before I ask for your closing statements, I just want to let people know about a couple of key dates. That Election Day is Tuesday, November 6th, in case this crowd didn't know that. If you wish to register to vote, or if you've moved since the last time you voted and you need to re-register, you may go online at any time, or you can mail in your change as long as it's postmarked by October 22nd. And vote by mail requests have to be received no later than October 30th. If you go to the League's Voters Edge website, and it's votersedge.org, you will find, and you plug in your street address and zip code, you'll be able to see your own ballot with links to the candidates, the issues, the ballot measures, and information about the voting process itself. So with that, it's now time for the candidates' closing statements. They'll each have 2 minutes. And we'll begin with Anna, since we started with Lori.
Thank you. Thank you all for being here today and for listening to everything. I am proud of my record as a criminal prosecutor. That case I mentioned where I got $6 million for victims of home foreclosure fraud, I took that case to trial. And it took 2 months We had 20 witnesses and 2,000 exhibits in that case alone. Closing arguments lasted 4 days. My rebuttal lasted 3 hours. Those are the kinds of cases that I've tried. Complex, challenging, leading teams of attorneys. I've tried them and I've won them. And in fact, I won 3 national awards for my work as a prosecutor. Now I'm running to be your district attorney because Marin needs a district attorney who will stand up for everyone. Stand up for victims of sexual assault, stand up for our immigrant community, stand up for our environment, stand up for the mentally ill, for the homeless, for every single one of us who wants to live in a safe community where we are free every single day to live the life that we know is our best and to our fullest potential. It's the district attorney who has the power to make sure that our communities are safe and that every one of us, every one of our kids can live that kind of life. That is why I am running. That is why I'm proud to be endorsed, the only candidate endorsed by the Marin County Democratic Party, the Sierra Club, Congresswoman Lynn Woolsey, Indivisible Marin, Supervisor Kate Sears, Supervisor Dennis Rodoni, 6 mayors, including 4 city council members in Novato, 4 out of 5. That's why they're supporting me. It's time for change in Marin County. It's time. And it's time for justice with integrity. That's why I am running. Be honored to have your vote. Thank you.
Thank you. Tonight's the first night I've heard that term, justice with integrity, and I think you really all need to, again, remember that knowledge is power. I'm looking at an email that another person received from Ms. Pletcher as a fundraiser, and it said, "Have you heard the news? We won a huge victory over our opponent, Lori Fragoli's team, who attempted to challenge Anna's statement on the November ballot and was denied in court." And we have a copy of that case here. My name does not appear in this. It is Anna Pletcher versus the Registrar of Voters. And the bottom line was, yes, she prevailed. She was able to successfully get something on her ballot, which was legally impermissible. And but for the Registrar of Voters being late, it would not be on there. And the judge's ruling says, the statement shall not include the party affiliation of the candidate, nor membership or activity in partisan political organizations. That's the election code law. When the judge made his ruling, he said that it was an anomaly that that information would be included in the ballot statement. And he said, to quote the ruling from Judge Chernus, "Today's ruling unfortunately creates an anomaly of including impermissible material in the voter guide, which under different circumstances would ordinarily have been stricken." Is that integrity, intentionally violating election law? You can decide that for yourselves. I was also accused of putting something in this handout here that infers I'm the only Democratic candidate endorsed by non-existent entities. Actually, it says every former Marin County district attorney. As I sit here today, I'm endorsed by the staff in my office, by the sheriff, by Mary Jane Burke, by almost every police agency in this county who is involved, and by 4 people that really know what this job's about. The only 4 people: Paula Kamina, the first woman ever elected DA, and the prior 3 DAs before her. So I've earned their votes, and I hope I've earned your votes as well.
Thank you.
Thanks.
Thank you so much to both candidates, Lori and Anna, and to our moderator, Yoel, and to our timekeeper, Elaine. And thank you all for coming tonight and coming out for this. This concludes our debate.